Okay. All right. Let's go ahead and get started. Hello, everyone. Thank you so much for being with us tonight. Welcome to the Maria Lean Gay Heart for Haiti Foundation's community outreach event on immigration law updates and TPS, temporary protected status changes. My name is Vanessa Pierre Parker. I am the co-founder and president of the Maria Lean Gay Heart for Haiti Foundation, and I will also serve as the facilitator for today's seminar. We have a great discussion prepared for you all. We're hoping that it's educational, that it's informative, and that you will also have some tips on do's and don'ts as you consider how you might handle your particular status. First, I'd like to share a little bit about the foundation in case any of you don't know who we are and what we do, if you're not familiar with us. The Maria Lean Gay Heart for Haiti Foundation is a federally recognized 501c3 tax exempt nonprofit organization. We are dedicated to empowering and promoting the overall well being of Haiti, her descendants in the United States, and across the globe. We are on a mission to facilitate rebuilding Haiti by channeling sustaining and life changing resources through fundraising and sponsoring efforts, one individual, family, and community at a time. To learn more about the foundation and the three initiatives, please visit our website at www.magheartforhaiti.org. Okay, the three initiatives that we focus on are community outreach, leadership development, and mental health support services. So, as we prepare to get started, I'd like to point out a few housekeeping items. Number one, please mute your microphone if you are not speaking. Number two, should you have any questions for our presenters, please use the chat function, and as your facilitator, I will ask them on your behalf. And lastly, please only ask general questions and no personal legal advice. And we do have a brief disclaimer for you. The information shared during this seminar is for general knowledge and is designed to provide you with a baseline for some questions to ask, for things to consider as you work to handle your own status. So, should you have any questions and you wish to connect with one of our experts on the panel today, please reach out to us and we'll be happy to share their contact information with you. Okay. Without further ado, I would like to introduce to you Attorney Uchechi Uchegbu. The Mercy Law Firm, LLC, is proudly led by Uchechi Uchegbu, attorney at law. The Mercy Law Firm is a premier law firm in Laurel, Maryland. They specialize in handling cases involving bankruptcy, civil litigation, criminal law, family law, personal injury, and immigration law. Uchegbu is originally from the Maryland, D.C. area. She graduated from the American University with a Bachelor's of Arts in Law and Society. Shortly after finishing her undergraduate studies, she moved to Boston to pursue her Master of Criminology degree at Boston University. Attorney Uchegbu graduated from Touro Law Center with her Juris Doctorate and sat for the Maryland bar immediately thereafter. Attorney Uchegbu is admitted to practice in all Maryland state courts and in the Federal District Court of Maryland. Uchechi is a member of the Women's Bar Association of Maryland, the Maryland State Bar Association, the Montgomery County Bar Association, and the Nigerian American Lawyers Association. In her free time, Attorney Uchegbu enjoys traveling to new places and spending time with loved ones. Uche, thank you so much for being with us. Welcome, welcome. Thank you.
And thank you for having me. I appreciate being invited to speak at this esteemed seminar.
Thank you very much. And our next presenter is Lloyd Rosa George, attorney at law. With over a decade of experience with the immigration legal arena, Lloyd Rosa George brings a wealth of hands-on experience, dedication, and integrity to her practice. A graduate of American University, Washington College of Law, Ms. George states, and I quote, "My mission is to provide my clients with a safe space, providing honest and thorough legal counsel," end quote. Ms. George also brings a personal touch to her practice. Having immigrated to the US as a child with her family, She credits the honest and kind-hearted pro bono attorneys who helped her family successfully navigate their immigration issues as one of her inspirations to provide the same quality of service within her practice. Ms. George is an active member of the American Immigration Lawyers Association, DC chapter, a board member of the Ethiopian Community Center, and is the former chair and vice chair on Washington, D.C. Mayor Bowser's Commission on African Affairs. Ms. George has also lobbied for the particular interests of African immigrants on Capitol Hill. She frequently appears on television and radio programs addressing the immigrants' unique perspectives, and she regularly partners rather with faith and community-based organizations to conduct free immigration legal workshops. Some of the select media appearances include Al Jazeera, the Noah Daily Show, one of my favorites, and a host of others. Welcome, Lloyd. Thank you for being with us today.
Thank you for having me.
Absolutely, not a problem. So let's go ahead and get started. We'll start with you, Uche, if you don't mind sharing with us a little bit about the adjustment of status in general and things that are coming down the pike in terms of this new administration being in office and some information that we can know in general.
Once again, thank you for having me. I'm just going to spend a few minutes going over the green card application process, especially with regard to family-based petitions. That is my particular area of interest, and those are the cases that I handle the most with regard to my immigration practice. And I thought that it would be good to just take a few minutes to touch on it, considering the fact that that is the more popular one, and 90% of the people that walk through my door, the first question is, I'm married, what's next? So what qualifies as an immediate relative in terms of filing for your green card application? The spouse of a U.S. citizen is a popular category, the marriage-based petition. An unmarried child under the age of 21 of a U.S. citizen, the parent of a U.S. citizen. Those are the three categories of immediate relatives. Now, you, as a U.S. citizen, you can petition for your children over the age of 21, and you can petition for a spouse, but do keep in mind that there are longer wait times for those categories because they're not classified as immediate relatives. Now, you are eligible for adjustment of status if you are currently in the United States, because you have to have a status in order to adjust your status. You have to have been inspected and admitted or paroled. Generally, this is regarding individuals who, and again, of the more popular ones, come in on like a B1, B2 visitor visa, and you have overstayed your time that was given to you at the border, or you have any other specification or qualification by which you came. But the more important thing is that you were inspected by an immigration officer who looked through your passport, who assessed your visa, and with that, you got an I-94, which is basically a record of your entry into the United States. You also have to be physically present in the United States at the time you file your 485, which is also known as the green card application. Now, there is a platform for which you, as a U.S. citizen, can file for your immediate relative who is not in the country, but that is regulated by the State Department, who in turn regulates the consulates, who are issued visas. But that's a different conversation that is not a part of my presentation today. But I just want to make it clear that if you are filing for your immediate relative in the United States, that's one process. But you can also file for your immediate relative who is overseas, but that is through another wing of process entirely. But it is possible. Now, there are bars to adjusting your status. One of the more popular ones are, of course, crime. Certainly, crimes involving moral turpitude is a huge one, because one of the benchmarks for being able to qualify to have your status adjusted is that you display good moral character, that you are a good person. That is questionable, considering all the things that are happening today and with the outgoing administration. But nonetheless, you have to display good moral character from the time that you file your initial application all throughout until you get to naturalization. Unlawful presence is another one. If you are in this country, you are given a time period by which your visa will allow you to stay here when you are being inspected at the border. Um, as long if you stay a day over the time that they have given you at the border, which is typically 6 months. It really just depends. You are out of status. Now, there are certain benchmarks of time for which there are bars, but at that point, if you leave the country after you have gone over your duration of stay, you have invalidated your visa. And if your spouse or your child, your parent or your child tries to file for you, then you will be subject to having to have a waiver applied and then approved before your application can advance for you to come into this country. Now, a waiver is essentially seeking special permission to overcome the offense of having either committed a crime or been in this country beyond the duration of stay that you were given at the border. And at that time, it is up to USCIS, who will look at the totality of the circumstances, who will decide whether your waiver will be approved so that you can continue to adjust your status. So the point of the matter is that um, not only do you have to have, not only do you have to be currently in the United States, not only do you have to be inspected and admitted, you can't have anything that would bar your adjustment. But if you do have something to bar your adjustment, in most cases, you are able to have your um, petitioning immediate relative file a waiver on your behalf. And like I said, upon approval, that is how your application can be advanced to the next stage. So what I wanted to do is kind of lay a framework for the initial qualifications or requirements to be able to file. But I wanted to go into a little bit of what I find is the real issue, and that is the genuineness of the relationship. I find that the reason why I think it's important to address is because not only is it one of the more popular ways that people want to adjust their status, I also find that people seek out lawyers kind of like when things have gone totally wrong. I think it's perhaps because obviously from an economical standpoint, it is expensive to have to pay an attorney in addition to paying for the filing fee, in addition to paying for your medicals. But I kind of wanted to touch into what is immigration really looking at when you are filing for your green card application. They're looking for the bona fide of the relationship. They're interested in the first part when the US citizen is filing his or her application known as the I-130. What they're trying to do is they're trying to establish the relationship between the petitioner and the beneficiary. Of course, like I said, the popular one, the marriage, you're going to submit your marriage certificate. But even more so, you have to submit documentation to further describe the relationship to the immigration officer. Some of the things that they're looking for are your taxes. It is assumed that a husband and wife would be filing their taxes, married, filing jointly. Sometimes I have people come in and they have taxes that are married filing singly. I'm not saying that you're not able to do that. What I'm saying is it's best to submit tax returns where you are demonstrating the status quo as to what many couples do with their taxes, which is you're filing married and then you're combining your income on your taxes. That's what makes a household. Um, if you have a joint lease or a deed to the property where both names are on, that's another good one. What I see a lot of is bank accounts, which is good, But sometimes they bring me a bank account that has no activity. That does not indicate a day-to-day life with your partner. You have to, so most couples have a joint account, although they have their private finances separated, obviously. But for the most part, you're buying gas, you're buying groceries, you're, paying for Uber Eats, you're paying for your kids' daycare, if you have anything like that, and you're doing it from your joint account. So what I tell people all the time is to submit maybe 2 to 3 months worth of your statements, but make sure that there's activity on it. Don't bring me a statement from Bank of America saying that you opened up your account on April 1st of 2021, and then there's also no activity. That would not help you. Another thing that I like to see is affidavits from individuals who can ascribe that they were perhaps not only at your wedding, but they can perhaps say that they knew you and your spouse before you got married. They spend time with you. They were at your wedding as well. They can ascribe to the genuineness of your relationship. Those things are helpful. I always tell them to not only does it have to be properly written, make sense, also have it notarized if it's possible, because there's weight in a notarized document. Um, I know that some people submit pictures, ongoing pictures throughout the course of your relationship. I have received pictures where the woman is wearing one hairstyle, and that's supposed to have been the photos on the evolution of your entire 10-year relationship. Make it realistic. You have gone places, you have done things. Now, I'm an African. We're not really good with romance in terms of taking pictures and all those type of things. But I tell people we are in the United States where romance is important here. You have to sell it to them. Even if it's not what you believe, you have to create that to the people that are going to be adjudicating your application. Just one second. And I tell people all the time, not only should you have a complete application with your supplementals that you submit when you are making your initial filing, it's also good to bring updated supplementals at the time of your interview. I also think that that's very important, not to rely on what you submitted a year and a half ago, because there are long wait times before your interview. It's also a good idea to bring evidence to show that the relationship is ongoing. I think that's also very important. I also want to touch on the interview itself. And again, this is another thing where I think a lot of people don't realize the weight of how important your interview is. Your interview is the final step, and it's an opportunity for them to put a face to a name. I do know that there are some immigration officers that put more weight on the interview than your documents, because anyone can put your documents together. They want to see you and your spouse. They want to see that chemistry. They want to see that you are a representation of what you filed. This may sound very minor, but I have to educate people. Something as simple as your dress. If you're not going to wear it to a job interview or church, the last place you should think about wearing it to is an immigration interview. First impressions make all the difference. And what you want to do is, if you look good, or if you're presentable, or if they see that cohesion in what you and your spouse are putting forth, then perhaps they may go a little bit easier on your interview, among other things. I try to remind my clients and prospective clients that immigration officers are people, they're not robots. So they're also inclined to um, lead with how they feel and lead with preconceived notions that they have. I do know, and I'm sure Attorney Lloyd can speak to this, that they're very, very harsh with people of color, especially Africans. I think that they hate Nigerians, but that's another conversation for another day. But nonetheless, I think that because we have an uphill battle, we have to make sure that our applications are airtight. One of the things I tell my clients is again, because you're selling this idea of cohesion and togetherness, from the moment you are getting out of your car in the parking lot, hold hands, or maybe, um, you know, have an arm around a shoulder or arm around the waist or whatever it is. I know it may seem a little quote unquote cheesy, but if you can get your body to do certain things, then perhaps your mind will go there. So again, build that chemistry regardless of what you may be culturally used to, or regardless of what you may want to do. If you build that chemistry, the immigration officer will likely see it, and it will reflect in your interview. Another important thing is the immigration officer is focused on the intricacies of your relationship. They want to know the day-to-day activities as husband and wife. They want to know what are your futures as a couple. And they make all kinds of questions. They make all kinds of inquiries. They can ask you things like, what is your spouse's date of birth, to what high school did he attend, to what are your parents' names, to what are your siblings' names. And it is really up to the immigration officer as to how he or she wants to conduct their interview. And these days, I've seen a lot of different things. I'm regularly in Baltimore or Arlington. Just last month, I had an immigration interview in Montgomery, Alabama, and it was a bit different than what I normally see in Baltimore. And what I have been seeing a lot are and I always tell my clients to please be prepared for a Stokes interview. A Stokes interview is when the immigration officer um, separates you. So you don't even have an opportunity to go into the room and have your well rehearsed presentation. As soon as you get there, they take the citizen spouse first and ask her questions and send her into the waiting room, and then ask the beneficiary spouse to come in and ask the same questions. And they're looking for similarities. So again, that is those are the kind of strictness that immigration is using these days. And though we have a new administration, we cannot expect any changes to be overnight, which is why it's important to be prepared. I do know that when I first started almost 10 years ago, I know I'm not imagining this, just things have just been like this for so long. But I do believe that they would give you some sort of an approval on the spot, or at least tell you that everything looks good. You would have some indication as to what the immigration officer would be thinking about recommending your application for approval. These days, what they're doing is they're just giving you a piece of paper acknowledging that you were there and telling you that your case is being held for further review, and issuing RFEs, which is a request for more evidence, later on. Um, when you get back to your home, or issuing it to your attorney much later on, and then taking longer and longer to make decisions. So um, I will say that it is, I wanted to touch on this topic a little bit tonight because, like I said, in my area of practice and with the clients that routinely come to me, marriage based is those are the cases that are walking through the door primarily. And there's one other thing that I find that my clients or prospective clients deal with a lot, which is lack of consistency. I find that a lot of clients um, come on a visitor visa. What you represent on your visitor visa has to be consistent with what you put on your green card application, has to be consistent with what you put on your citizenship application, has to be consistent with what you represent to the immigration officer. What people seem to underestimate is immigration's capacity to have a very long memory, especially with their computer. If you studied in 1971, they're going to remind you in 2021. So what ends up happening with, I think maybe 99% of my cases is their cases are kind of railroaded, because now you have to answer for something that you are representing that it's different from what you said in your visa application. And the interesting thing about immigration is that they can either ask you in a request for more evidence before you come to the interview, or they can ask you at the interview. Either way, you're going to have to answer for the inconsistency. So I think that that's very important. And I will say, above all, um, a successful application, regardless of whatever the category is very important to your key to regularizing your status and staying here. I think it's very important to solicit the services of an attorney, whether it is by contacting Catholic Charities or any of the like pro bono attorneys, or investing the money in getting a knowledgeable one. Because what I find with immigration, once your application gets into a ditch, it is very hard to get out of, especially considering the extremely long wait times. So that is kind of where I wanted to end on the marriage-based aspect and just the adjustment of status application in general. Like I was discussing with Vanessa earlier, I wanted to kind of touch on the immigration reform that the Biden administration had been talking about. But my concern, and Lloyd, if you feel different, please opine, and you can touch on that when your time comes to speak. But there has been absolutely no significant movement since it has been first proposed. It is stuck in Congress. There are no real changes at this time that are worth touting, aside from some things that have to do with the adjustment status process. Like, there's a particular wing of applications that we were forced to put together. It's called the 944 form. It's like a self-sufficiency kind of thing. And if I go into just talking about that, we'll be here until midnight. So I'll not talk about that. But, those kind of things, there was supposed to be some alleged significant price hikes on the application fees itself, which are not happening. So I kind of hesitate to go into something that has not been passed, and that could, as a part of the bargaining between Congress and Senate, the House and Senate, excuse me, could potentially transform. And what I find with these kind of conversations is that my clients will hang their hat on something that may not come to fruition, which is why I like to talk about what is solid. But nonetheless, that concludes my part of my presentation, and I hope that it was beneficial to someone listening.
Absolutely. It was amazing. I appreciate that. A wealth of knowledge, as I knew it would be. So I'm so grateful for that, for sharing all this information. I do have some questions that'll come up for you, and you've done a great job giving us some tips. I was feverishly writing as you were sharing some things, because I think it's important that people know some of these do's and don'ts. So we'll get to that at the end of our segment. But let me segue over to you, Lloyd. If you could tell us a little bit about, starting with TPS, what exactly does that stand for? For those of us who may hear this for the first time and are not very familiar with it, and then what are some changes can we expect for the Haitian population specifically, but also in general?
Yeah, absolutely. So TPS stands for Temporary Protective Status, and it's something that the Secretary of the Department of Homeland Security designates a country depending on what's going on the ground in that country. And more specifically, it's usually when we're dealing with some sort of temporary catastrophic event, whether it's ongoing armed conflict like a civil war, or an environmental disaster like an earthquake or a hurricane or a volcano eruption, or other extraordinary and temporary conditions. The Secretary can extend TPS after a review of country conditions, and typically extensions are for increments of either 6, 12, or 18 months. And the decision to extend TPS is typically made at least 60 days before the TPS designation is set to expire. That's kind of a brief summary of what it is. Then there's who's eligible for TPS. TPS boils down to, is your country designated for TPS? So are you a national of a designated country? Then have you filed for status during a very specific registration period? So that could speak to maybe somebody just came from Haiti 2 years ago on a visitor's visa, they've overstayed, and now they want to explore what they can do, and they know about TPS. So they're thinking, hey, why don't I just apply for TPS? Unfortunately, that's not an option because you would have had to have registered during the initial registration period. And so for Haitian nationals, that would have been either in 2010. The first designation was January 21, 2010. The second redesignation was July 23rd, 2011. And between that time and now, if you are eligible for TPS, it will be because you timely re-registered every time the Secretary of DHS extended TPS for Haiti. So those who have had TPS and timely re-registered in the last 11 years and change now, they have been able to benefit from three main benefits. I was redundant with that, but they've been able to take advantage of three main benefits. Number one is they're protected from being removed from the country. That's critical because for all sorts of reasons you can be removed, and the simplest being that you have no status. So even if you've committed no crimes, you haven't committed any immigration fraud, you haven't used any fake documents, you haven't been placed in removal proceedings, even if none of that has happened yet, if ICE crosses paths with you as we speak and you're undocumented, you're exposed to being placed in removal proceedings. But if you're somebody with TPS, you are not in danger of being removed. Now, TPS is one of those strange middle ground statuses in that once designation is terminated, you're back to whatever you had before TPS was designated to your country. That's critical because a lot of people assume and presume that TPS is a pathway to another type of status, namely a green card, but it's not. It's literally supposed to be a shield to protect you from removal for the duration of that temporary crises in your country of origin. It is not a path to a permanent status. So in that context, when you're thinking about the benefits of having TPS, it literally just shields you from being removed while you're waiting for conditions to change in your country, or if there's any change in your personal life that could open up a door to status. And we'll talk about that towards the end of my little spiel. The very last and very crucial or beneficial aspect of having TPS is you get a work permit. So, and you also get what's called advanced parole if you affirmatively apply for it, that allows you to travel in and out of the US, typically for one trip at a time. You have to actually provide what the reason is for the travel, and it's usually if there's some sort of a humanitarian or medical issue, or if you can demonstrate financial loss. That's usually tied in with a job assignment, but it's usually humanitarian issues. So to that end, if you've got TPS and let's just say somebody passed away in Haiti and you need to go and bury them, the way that you'd be able to travel and still be able to come back in is if you got advanced parole. And that's something that you can ask for when you have TPS. Those are the three main benefits of having TPS. Number 4, sorry, I had to go with my list of things that I wanted to cover. So even though the earthquake happened 11 years ago, can Haitians still have TPS? This is what comes up most often when I cross paths with Haitian nationals who just came into the US or came in after the designation periods. And as I explained earlier, if you did not timely register, either back in 2010 or 2011, and if you have not maintained re-registration between 2011 and 2017, and I'll talk about why 2017 is critical, then you cannot simply come in and file for TPS at this point. Now, this kind of takes us back to what's happened to TPS between 2010, then the redesignation in 2011, and right now. As I stated earlier, TPS can be extended by the U.S. Secretary of Homeland Security, and it was not until 2017 that it was, let me rephrase that, 2017 was the last extension of TPS. January 1, 2018, under Trump's administration, they announced that as of July 2019, TPS would be terminated for all Haitians. So any of you who have TPS or have family that have it, you'll remember 2 years ago under Trump's admin, there's this big uproar about TPS ending and what does that mean and what's going to happen next. And it wasn't just Haiti that was on the chopping block when it came to TPS. There were a few other countries, including El Salvador, Honduras, Nicaragua, Sudan. I feel like I'm missing one. I think it's Nepal. They were all on the chopping block under Trump's administration. When that happened, there was a flurry of lawsuits that were filed in federal court where people were saying for different reasons that the termination of TPS designation for their respective countries were illegal. So the case that dealt specifically with Haitian nationals was Sagat versus Trump. And that was in 2018, shortly after the announcement that TPS designation would be terminated for Haitians. And so a combination of that lawsuit, as well as the lawsuits that were filed for the other countries that had their TPS on the chopping block, led to various federal courts around the United States taking action, namely to issue what was called a temporary injunction. So temporary injunction just means a pause. And so when these lawsuits hit the fan and the courts were trying to sort out the legalities of the termination of TPS, for Haitian nationals in specific, it was the U.S. Court of Appeals in the Second Circuit in New York that led to the temporary injunction on the termination of TPS. Fancy language for a federal court in New York basically said, hey, while the courts are figuring out if the termination was legal, we're going to put a pause on the termination of TPS. And those of you who timely registered in the past or re-registered in the past, your TPS status, more specifically your TPS documents, are good until October of 2021. Now, TPS documents is very distinct from TPS status, and that's also something that a lot of people get mixed up on. They think that right now they still have TPS and it's been extended until October of 2021. No, for what it's worth, TPS has been terminated since 2019. It's just the enforcement of that termination has been paused, and until the courts figure out if that termination was legal, your TPS documents, which really boil down to your work permit, are valid until October of 2021. Again, that's a critical distinction because I hear a lot of folks saying, hey, TPS has been extended till October 2021 for Haitians. No, it's not. All that's happened is there's been a pause on the termination, and if you've got a work permit in your hands that has long since expired, and we're talking about expiration dates, there's 3 different sets of expiration dates that you can have on your work permit or on your TPS approval notice. It will be either, and these are 3 critical dates, either July 22, 2017, January 22, 2018, or July 22, 2019. If you have either a work permit or a TPS approval notice with either one of those 3 expiration dates on it, those documents are still valid up until October 4, 2021. I threw out a lot of dates. It's kind of weird having this discussion without having people to nod their heads. So I'm presuming that those dates were caught. And again, that's critical because, and I just want to repeat this because I hear this over and over again, TPS has not been extended until 2021. It's terminated, but what has been extended, for lack of a better word, is the use of your TPS documents, which is either your work permit or the approval notice for your TPS status. So in theory, what that means is if you need to show up at your job and have to prove that you're eligible to keep on working, in theory, if you give your work permit plus something that's called a federal register, and the federal register is something that the government issues that pretty much documents what different policy statements. And there's a federal register, and I had sent the PDF to you earlier today, and so hopefully you could share it with your listeners. The federal register has clear language that if you've got a work permit or a TPS approval notice with one of those 3 expiration dates on it, you are able to continue working through October 4, 2021. So whether it's working or maybe getting a real ID issued ID or driver's license, you would then also show the expired document and the federal register. Some employees get it, employers get that. Many don't have time to read through a register. So if you're handing over your expired document and the register, they're going to look at it like, well, I don't have time to read this. It's in the register has a lot of legalese language, and quite frankly, it's not very user friendly. So what I tell a lot of my clients who hit a wall with their employers because they're looking at their work permit and saying, hey, your work permit expired in 2017. What am I supposed to do with this? Then I typically type up a very succinct letter, which won't have much to it except this is what you are required to observe. Here is the law. Here's the federal register. You can find the information here. And most of the times, employers will see that and say, okay, I get it. But to that end, that's just something to keep in mind, that October 4, 2021 is as good as, or is really the cutoff for how good your documents are right now. Now, there are a lot of things changing under Biden's administration and very quickly as far as policy changes. We don't know if the new Secretary of DHS will not redesignate Haiti for TPS. Maybe he will, maybe he won't. So there's a lot of gray about what could very well happen between now and October. And that kind of neatly segues into what happens if Haitians who had TPS always re-registered and the DHS secretary does nothing to redesignate TPS. Or let's just say that those lawsuits that are tied up right now in federal court don't go in our favor. And the courts decide that the termination of TPS back in 2017 was legit. So then what happens? In theory, and again, I say in theory because many things can change on the ground, but in theory, if TPS ends for Haiti, then there's going to be what's called a 120-day orderly transition period, where in essence, it'll be a moratorium. Nobody will be deported. Nobody will be placed in removal proceedings. And that period of time is really a period of time for you to get your house in order and leave. I say in theory. Air quotes, because in the past, when it comes to humanitarian types of benefits, which TPS falls under that category, when designation is removed, in the past, ICE has taken a stand back perspective, which is, hey, we get it. You've been here a while. This was a humanitarian benefit. We're not going to put our sights on you and put our efforts into removing you from the country, not unless there's other things that you've been doing, whether it's committing crimes or immigration violations, et cetera, et cetera. Under Trump's administration, we pretty much saw that as a possible way that this could play out the door. Under Trump's administration, we were all on the edge of our seats because he had a zero tolerance policy for immigration violations. So the fear was very real back in 2019 when the word came down the pike that TPS was on the chopping block. Things are shifting now. I'm going to go back a little to Obama's administration. Under Obama's administration, he had something called prosecutorial discretion, where ICE had the discretion based on certain priority factors as to whether or not they would enforce removal. And so what was typically at the low end of the totem pole where they would just leave you alone is if you had something like TPS, and now TPS was done because the issues in your country of origin were no longer eminent enough to grant you or warrant you any protection. So now you have nothing. Under Obama's administration, using the hierarchy of prosecutorial discretion, they left you alone, as long as you didn't have any other issues, typically crimes or prior orders of removal. There is, I would say, more than a rumor. It's something that's been discussed and leaked in immigration circles that under Biden's administration, ICE is going to be issuing a new edict, rules, policies for them to now also reintroduce prosecutorial discretion. And there is rumors that it will be even more flexible and generous than under Obama's admin. Similar to what Uche was saying earlier, I don't want to opine on things that we don't have in black and white yet, but at the very least, knowing that prosecutorial discretion is more than likely going to be reintroduced, then this means that if for whatever reason the new DHS secretary does not redesignate TPS for Haitians, and if the federal courts do not find that the termination of TPS was illegal, and so now everybody that had TPS has nothing, then we are hoping and praying, and I think it's more likely than not under Biden's administration, if and when TPS is off the table, the next thing that will happen, the next thing that won't happen is that you'll be placed in removal proceedings. But what will happen is you'll be left with nothing. Because remember what I was saying earlier, TPS does not give you status. It just puts a pause, and whatever it is that you had before TPS is what you go back to. That takes me to the very last thing that I wanted to talk about, and I see I'm running out of time. And that's, what options do I have if and when TPS is no longer an option and I now have nothing? See, this is what happened when you rely on papers. Okay, so if you have nothing and you're wondering what and how can I regularize my status? So one of the main ways, and many things can happen in 11 years, and one of the main ways reverts to what Uche was talking about, which was family-based petitions. So you may have gotten married in the last 11 years, and your spouse is a U.S. citizen. You may have had a petition filed by a sibling, and now you have a visa available to you. And just for context, right now the wait time for visas, if a U.S. citizen sibling files for their brother or sister, is roughly 15 years. So if you had your U.S. citizen sibling file a petition for you back in 2006, I'm kind of throwing numbers out here without looking at the visa bulletin, but just in theory, and now that visa is available to you, there may be a way for you to be able to adjust status and apply for a green card based on that petition that your relative filed for you. Now, there are other requirements, especially if it's not an immediate relative. And again, this harkens back to what was just discussed earlier. I don't want to dig into all those layers, but family-based petitions may be an option for you that may not have been an option back when you initially got TPS. Another option is something called a U visa. A U visa is if you've been a victim of a very specific or particular type of crime and you are willing and able to cooperate with law enforcement in the prosecution of whoever committed that crime. The more common types are crimes of assault, whether it's domestic or you get in a bar fight. There's a list of other types of crimes, but those are some of the more common ones. Then there's something called VAWA, which is the Violence Against Women's Act. Even though it specifies a gender, women, VAWA is available to anybody that's been a victim of spousal abuse or elder abuse or child abuse, and where the abuser is either a legal resident or a U.S. citizen. It does not require that you have to cooperate with law enforcement, but it does require that you establish and prove your relationship to the abuser as either your spouse, parent, or child, and that the abuser is either a U.S. citizen or a green card holder. Another route to status is if, for whatever reason, you're placed in removal proceedings. If you are placed in removal proceedings after having been in the United States for at least 10 years, if you can prove good moral character, and if you have what's called a qualifying relative, you may be eligible for something that's called cancellation of removal, which is another path to a green card, but you have to actually be placed in removal proceedings for that. That's a mouthful. Those are 4 various ways that you may have a route to status if you find yourself without TPS anymore. But the best way to sort any of that out is to sit down with an immigration attorney. And that takes me to the very last part of what I wanted to discuss, which is who should you talk to if you need answers to what your options are and what's available to you. So I always tell people, if you don't know what your status is or how to get out of not having status, if you've committed crimes, if you've ever been placed in removal proceedings, if you've ever received a request for evidence and it's overwhelming and you don't know how to respond to it, that is absolutely the time to sit down with an attorney. Make sure that you're talking to an attorney. There are a lot of people who have law degrees, but either didn't pass the bar exam or didn't pass the bar exam in the United States, or they were disbarred, but they are able to still present themselves as attorneys. And in different communities, they're called different things. In the Latino community, they're called notarios. I find in the African and Caribbean communities, they're usually called immigration consultants. Or they will call themselves attorneys and just won't clarify that they're not licensed to practice law in the United States. Or they won't let you know that they've been disbarred. So it does take some homework on your end to make sure that you're actually sitting down with an attorney. So that's number one. If not an attorney, and for instance, if you don't have the money, there are a lot of what are called BIA, Board of Immigration of Appeals, accredited legal service providers. And I provided you a list of BIA legal service providers all over the United States. So if you can't afford a private attorney, at least go to a BIA accredited legal service provider. In this area, in the DMV area, there is a plethora of them. There's no reason why someone in this area should not have access to quality legal counsel. I always tell people avoid street corner advice, which boils down to just because your aunt had a situation, just because your friend had a situation, doesn't mean it's like yours. Number one, people don't tell you all their business. Number two, even if they're telling you their business, one little fact, just one little fact can throw off how those options play out for you versus for them. Number three, if they're not an attorney, they're not an attorney. So they're not going to even understand all the nuances. The list goes on, but just avoid street corner advice, which could be from friends, family, he said, she said. Stay out of trouble with the law. That may seem very obvious, but for many people, they don't get it. A lot of times people think if they get in trouble with the law and then they get probation, In Maryland, there's something called probation before judgment, which it's a way to avoid any jail time and or any conviction on your record. But for immigration purposes, PBJs function just as a guilty plea. And so avoiding criminal issues, avoiding running around with folks that are in trouble. If you're Black and brown, we already know we're disproportionately targeted. And so you could be at the wrong place, wrong time with the wrong people and just get caught up. And then you have to deal with defending charges in criminal proceedings, which very well can have implications in your immigration proceedings. I think I'm going to stop right there. I'm looking at the time, but that's it.
Amazing. That is just amazing. That is a lot of information. Again, feverishly trying to take notes and paying attention to the questions. That there's a couple that came in, and in the interest of time and to honor everyone's time, I am going to ask a couple of those, and then we'll wrap up. But so much information. We have a list of do's and don'ts. As you were speaking, I did try to take notes, and we'll go back and review the recording so I can make sure I compile a comprehensive list, and we'll make that available on our website for everyone. But one of the questions that we have, Uche, I think this one is for you. So the question is for the waiver process. How often are waivers approved or denied? Are they hard to get approved, or does it just depend on the offense?
Well, I would say that waivers, more so than depending on the offense, depends on the U.S. citizen demonstrating the hardship that he or she would face if the beneficiary is not allowed to join him or her in the United States. Now, the hardship element, there are several different factors. Again, for the sake of time, I can't really do too much, but the point is that you have to put together a very, very detailed and thoughtful presentation to immigration as to what type of hardship would you face. They look at different categories such as your mental state, your psychological outlook on the situation. They look at perhaps the distance between the United States and the beneficiary's home country. They look at perhaps whether there are health issues that you would face if you had to leave and join the beneficiary in his or her own country. They look at the employability. Are you going to be able to get a job that's going to be able to take care of you and your spouse? And the standard of living would be terrible. So the waiver process is very, very unique. It is very, very detailed and involves a lot. I think in terms of, obviously, it is discretionary. So it makes it a little bit harder to get approved, and the standard is very high. But of course, if you use a qualified and knowledgeable attorney, then have a higher likelihood of getting a approved waiver application. I can say that, I've been very, very, this practice has been very, very favored. We've never had a denied waiver application. But then again, my waiver applications are typically as big as a telephone book because I try to be as, thorough as I can. So it's possible, but you have to make sure that you have the right person who will put it together properly with the right evidence that you need.
Got it. Got it. Thank you so very much for that. Is there a timeline rendered for redesignation, or are we just in limbo indefinitely? That would be for you, Lloyd.
So typically you're supposed to assign redesignation within 60 days of the termination. So in theory, not redesignation, excuse me, extension. So in theory, we're no longer talking about extensions. Now it's just redesignation, if that happens. If you're asking if there's a cutoff or a deadline for when they can redesignate, no, there is not. Because the idea with redesignation is, hey, if something new happens in Haiti yesterday, I shouldn't have to have a deadline to when I could submit that. Let me say that a different way. If something were to happen 5 months from now, you would not know if something's going to happen in 5 months. So there can't be a deadline. Redesignation just means you had it in the past, something's happened in Haiti again, so we're going to redesignate it. So really the question is, will the DHS secretary consider whatever's happening in Haiti right now worthy, or does it merit redesignating TPS? I hope that whoever answered that question, asked that question, I hope that answers it.
Yes, it does make sense. Yes, that does answer the question. Thank you for that.
There's one thing I'm sorry.
Yeah, no, you're fine. You're fine. Please go ahead.
So right now, TPS, the validity of TPS papers is good until October. If no movement happens in the courts, and if the Secretary of the DHS does not redesignate TPS for Haiti, then the validity of the TPS papers is extended for another 9 months. So again, if nothing happens in the federal courts, because remember, TPS and the legality of its termination is being battled out in federal courts right now. So if the Secretary of the DHS does not redesignate Haiti as valid for TPS, and if we don't have any movement from the court, no decision, then the validity of your TPS papers will be extended another 9 months from October of 2021. So October 2021 doesn't have to be D-Day. If nothing happens, there's just another 9 months tacked on to that.
Got it. Got it. Okay, that helps a lot. Thank you. I do have a question about, so someone has a question. If they're granted TPS, does that make them eligible to apply for a green card at a later date?
It does not. Now, that's based on how the laws look like right now. As Uche was saying earlier, there's all sorts of noise. There was a proposed bill that hit Congress. One side of it pushed it through. The other side is, I haven't heard anything since it hit the other side of Congress. So I don't even know that they're belaboring over it right now. But anyway, part of what is being kind of hashed out in all of that is a path for people that have had TPS and had DACA and other types of temporary humanitarian reliefs to get green cards. If that pushes through and is successful, then the answer to your question is yes. But as the laws look like right now, there is no path from TPS to a green card. You have to have some other way right now.
Got it. Got it. That's very helpful. That is a question that we've gotten, so it's good to have that clarified. And this is for either one of you ladies. Can siblings file for each other?
I'll let you answer.
Well, I mean, it goes into what has been what I said and what Lloyd said. A U.S. citizen can file for his or her sibling, but it's going to take an exponentially long amount of time. It's not an immediate relative. And like Lloyd said, really is ranging between 10 to 15 years at this point. You file and forget about it, literally.
There's one thing I do want to say about that. I don't know the particulars of that category in this recent round of immigration reform, but the last round in 2012, they wanted to actually remove that category. And so what I told a lot of folks then, and I tell them now, if you've got $535, because that's the filing fee, laying around, and you've got a sibling that may or may not want to come to the United States, or maybe they're here and they don't mind waiting 10 to 15 years, petition for them anyway. Why? Because if that category is cut out, folks that already had a petition filed will still have that option. And also another thing that they've been trying to put into the laws is to increase the number of visas in each category. What that means is the wait time will drop from 15 to whatever to something much lower. So in theory, if you filed something now, which could take 15 years now, if the laws change, that wait time could drop exponentially. And or if the laws change, you may not even have that option. But if you at least petition for your sibling now, you lock it in. You still want to sit down with an attorney to talk this through, but that's something to consider. Even if 15 years sounds crazy, which it is, you never know how the laws can change.
This is true. Exactly. Thank you for that. So someone asked, if one cannot afford legal counsel, are there some basic steps they can take on their own to start the process of when the TPS is going to end, or some immigration status questions that they have? Now, I'm not a lawyer. I'm going to assume the answer to that is no. Speak to someone. I think you both ladies have pointed out on this. Of course, make sure that they are a licensed professional who are able to provide those services. But I'll let you answer that question. Besides speaking to a lawyer, would you recommend them take any additional steps to help their process?
I, I can give my opinion. The law is constantly, especially in this climate. Uh, and even as attorneys, there, for instance, I do, it has just now happened that immigration is like all I'm doing right now. It was before I was combining it with family cases, the car accident cases, because I'm a, general practitioner. But even with the multiple immigration applications that I do a week, I never submit anything without making sure that nothing has changed as of time that I'm submitting that application. I say all this to say, unless you are prepared to put in the time and the work and the research to make sure that you are knowledgeable about the law, to make sure that you are knowledgeable about what is required with your particular case and set of circumstances, it is almost as if you have a medical diagnosis and you don't want to treat yourself. You know you need to go to a doctor. I think it's the same thing with this area of law, or any area of law in particular. You need to consult an attorney, whether you save the money and hire one privately, or you go the pro bono route. Because immigration, like I said earlier, once you find your application in a ditch, it is very, very hard to climb out of it. It is something that you do not take chances with. Just invest the time and the resources to get a professional to help you, and know that you have done your part so that God can help you with your case the rest of the way.
I appreciate you clarifying that. That's very important, because we know a lot of people, especially in our community, they feel that they're educated enough, or they've spoken to their cousin or the next door neighbor, and they've gotten valid information, and they think that they can use that for their own case. But it's very important to speak to. And I love the way that you put that. You wouldn't take care of your medical needs yourself, so then why would you apply that same train of thought to this case? So thank you for clarifying that. Anything you want to add to that, Lloyd?
I think so. Hiring an attorney can be rather cost prohibitive. So at the very least, I tell folks at least pay for consultation, at least. So you can figure out what are the trapdoors in your case. You can figure out what do you have to be mindful of. Or avail yourself of the low bono or pro bono legal service providers. But by no means, not unless, as she stated, you've got the resources and the time to do the research and make sure you know what you're doing. It may take some sacrifice. Now, that does not mean that people have not filed for themselves and been successful. I've seen some very well self-prepped cases, but those are typically the exception. And again, even with the well-prepped ones, one thing goes wrong and you're in that ditch that Uche was referring to.
You don't want to be there.
No, you don't.
Absolutely. Absolutely not. Thank you, ladies. I'm going to take one last question, and I want to be mindful of your time, so please bear with me. This one is for Lloyd. It says, you mentioned something about a TPS recipient has 120 days once TPS expires to get their household together until something else comes up. If the recipient was under deportation order as a minor, but got married and filed an adjustment status that's still pending, does the recipient go back to being under deportation order once TPS is no longer valid in October?
So that's very case specific.
Very case
So
specific.
and that that makes me feel like they're speaking about a very specific issue, not general. So I would steer away from giving you advice that you can run to the bank with, because you'd have to dig into the weeds. But I will say that there is a different set of rules that apply to you if you were in removal proceedings, as far as how you can go from no status to green card. Even if those proceedings were initiated when you were a minor, you still have to either get your case reopened or you have to have your proceedings terminated. I'm throwing out a lot of lingo. And again, these are things that you would dissect with an attorney. But I do want to clarify that being in removal proceedings prior to TPS means that when TPS, if and when TPS is done, you're back to whatever you were. And if you were in removal proceedings, you're still in removal proceedings. That doesn't change. But again, with those types of very specific questions, you would want to have that question answered by an attorney. Because also applying for a green card through marriage, if you were in proceedings, looks different than if you were never in proceedings.
Absolutely, absolutely. And you're exactly right. That question does seem to be a bit personal. And I would encourage ladies, if it's okay that we share your information with our participants and others who are not able to attend. We can also share that information on our social media or on our website, so that if they want to retain your legal services, that they can do that with you all. Would that be all right?
Yeah, absolutely.
Okay, perfect. And also, you've provided some additional resources. We have the Federal Register, and some other pro bono services that they can consult with to consider if finances are an issue. Please, 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 we will share that information with you. You have our info at magheartforhaiti.org. Reach out to us. You can visit our website, magheartforhaiti.org, and we'll be happy to communicate with you, share the attorney's phone numbers or contact information, as well as the additional resources that they shared, which I think would be great for everyone. We don't have any time left. In fact, we are way over time, and I appreciate your patience. We have some great do's and don'ts. I mean, such as, be consistent on all your documents. I love the fact that, it sounds like PDA is acceptable. So show that to your immigration personnel. Dress appropriately. That was an amazing one. I appreciated that, because sometimes people don't take that seriously. So I wrote, if it's good for church, it's good for the interview. Put it on. It'll work, right? And then, of course, some don'ts. I think one of the main ones I'll point out is don't be ashamed. In some conversations I've had with people, there's a lot of stigma still around immigration status or even TPS. And so don't be ashamed, and don't let that stop you from pursuing legal advice from a licensed professional. Don't believe TPS is a pathway to another status. It's not. It's just a pause. Don't go for street corner advice. I like that one. That was great, because everyone's case is different. So you should consult with someone who is knowledgeable. As Uche mentioned, things are changing consistently. So you need someone who is well versed and stays on top of things. And don't get in trouble, folks. Stay out of trouble. Stay away from bad crowds who could get you into further issues. So thank you, ladies. Thank you so much for your time. Thank you for your wealth of knowledge. We appreciate it. And we look forward to working with you again sometime soon.
Absolutely.
All
Bye.
right, everyone. Take care. Thank you.